All right, welcome to another episode of Justice for Y'all. I'm Paul Painter, and with me is Andrew Bowen and Stephen Morrison. And gents, how's it going today?
Going well.
It's rocking along.
It's a relatively cold day for Savannah, Georgia, so I think Stephen and I are invested. You've got your nice sweater
Paul's
on.
sweating.
That's right. I'm sweatering.
Sweatering.
Yeah, I think it's the coldest day of the year. I felt like it was sweater appropriate.
Yeah.
It's a great day for a sweater. It feels really nice.
Well, yesterday,
Sun shining.
Yesterday when I woke up where I was in Colorado,
Right.
it was negative 15 when I walked out.
Which is cold.
I don't understand that. Is that absolute zero? I think it's absolute zero.
This is quite balmy by comparison.
Yeah.
Well,
but it's a wet cold.
Well, it is. 30 degrees in
That's the
Savannah gets to the bone. It really does.
Yeah, it's piercing. You got to have layers and some wind blocker if the wind's coming up.
Yeah.
The damp cold it finds its way.
Yeah.
Yeah. And you're getting ready to go up to Minnesota, later this afternoon?
Yeah, I am. I'm heading out this afternoon.
So what's the weather like there?
Last I checked, it's in the low single digits to the mid 20s, which is kind of prime winter weather. But when I head back, it's going to be, the spread was pretty impressive. It was like it was in the negatives, -2, 3, up to the 20s. So it's going to be a pretty, I reconstructed my winter ensemble. I have one that kind of breaks down into pieces and you can put it back together. So it's full Iron Man suit.
So you definitely need a hat.
Yeah.
Well, I mean, there's no denying, there's no two ways about it. That is cold weather.
Correct.
But just like with the humidity, the heat in a humid environment is more intense. That kind of cold in a dry environment is, again, still very cold.
Yeah.
But it doesn't feel as extreme as you might expect.
That's really true. I mean, when I was living up there, I had sort of a general rule of thumb when I was in walking distance to work. It was about a 15-20 minute walk through downtown Minneapolis. As long as it was above zero, I would walk to work. If it was -15, it would depend on the wind. If it was -15 and 10 miles an hour or less, I'd give it a go. The wind up there can be really brutal. I mean, of all the things that really gets you, it's the wind when it hits those open, flat plains and just rips across. You get like whiteout conditions. I remember we're kind of close to Christmas, brings back a Christmas memory. We decided to go visit family. We have dogs. We couldn't fly. So we had to drive, rented a Jeep, drove down from Minnesota to Little Rock, Arkansas to visit family. And it was a whiteout blizzard. And this Southern boy said, "Oh yeah, I can handle that." And I did handle it. My wife, she should not give her side of that story in the car. But I remember the worst part about it was like we were in two different vehicles. One was a convertible and we were open top, and the other half was just a melting sauna because full blast heat up top to try to keep the defrost going on the windshield, and then just toes were gone, which you do need your feet when you operate a motor vehicle. This is before I became a plaintiff's lawyer,
Right.
So and the statutes passed, nothing bad happened, but that was quite an experience.
That's white knuckle driving too.
Everything was white. I mean, just the roads, I couldn't see anything. I mean, you're just plowing through drifts.
Yeah. And you're tense the whole time.
Oh yeah, yeah. I mean, it's like you said, white knuckle driving.
Yeah.
And can't feel your toes. Your hands are numb from bleeding from gripping the steering wheel. A Jeep is not the best vehicle for that either. So just a lot of lessons learned.
Right.
I earned my winter stripes on that one.
Yeah, you did.
So what are we going to talk about today?
We are going to talk about preparing for trial.
You're tuned into the podcast where justice meets Southern hospitality. Broadcasting directly from Savannah, Georgia, join your hosts, Paul, Stephen, and Andrew of Bowen Painter Trial Lawyers as they chat about the legal difficulties you might face in everyday life. From the ports of Savannah to the busy highways that stretch through the southeast, we're your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
All
right.
So we got some trials coming up this year. We're excited about them, but we think about what we do and what people think it is we do, what we think it is lawyers do, and
Instagram versus reality.
Well, it's that, and also like movies. So you watch the lawyer movie and you see these lawyers. You got the montage of like reading books and drawing on whiteboards, and they seem very thoughtful and well rested. And
totally accurate.
Yeah, right. And so we thought, okay, well, let's talk about what it really looks like. And certainly when you see those TV shows, you're not getting ready for trial tomorrow, starting today. We'll maybe have some stories about how
in
we
our
tried to do
practice,
that.
I was say, I mean, there's sometimes public defenders, other kind of high volume, fast paced practices can be, hey, trials next week, tomorrow, sometimes. But for us, we get.
And those trials are generally short, maybe
Right.
half a day. Our trials will last, weeks. And, there's not to say there's not a lot at stake
Right.
with those, but there's a lot at stake with what we usually take to trial. So,
Well, and you're up against folks that are preparing equally. I mean,
Right.
you got to be on your game. You don't get to just wing it.
exactly. So let's sort of talk about big picture. How a case is and what we mean by getting ready for trial. So you get a case that you file a lawsuit, the defense answers, you usually go through some period of time for discovery where you have subpoena power to get facts from the other party, third parties, whatever. You do investigations, you do inspections, whatever needs to be done for the case.
Take depositions.
Take depositions, right. And then you get to the end of that, which can last from, 4 to 6 months to sometimes years. And then you often will get to where people will file some big motions to get rid of the case, that kind of thing. And finally, you get to a stage where it's ready for trial. And most places have a pretrial conference with the judge, that you have a pretrial order that kind of defines what the trial's about.
Right. So the pretrial order, the judge wants to know, okay, are there any unique issues in this case? What is the case about?
Or the witnesses.
List all your witnesses that you expect to or may call at trial. List all the evidence that you intend to admit to trial, and then when both parties do that, then you can deal with objections to particular evidence, objections to particular testimony, and sort of have a conference with the judge, get all of that hammered out, and then you've basically got a roadmap for the trial at that point. And really the work has begun before that, but that's sort of the operative document that's going to dictate how the trial goes.
Before we go, I mean, just talking about what trial, like what its purpose is and the whole thing there is some dispute about a fact in the case. There are legal issues, obviously, we know whether a defendant was negligent, but it is usually has something to do with one side says one version of the story, another side has another version of the story, and then somebody has to figure that out, and it's either a jury or a judge. Most of the time when we talk about trial, we're talking about jury trials, but sometimes there are cases where a judge will be the one who's making that determination. But this whole thing is because all of that process you went through, filing the case, litigating it through the discovery and the investigation, it came to the point where there were two sides to the story, and somebody has to figure that out.
Right. And the jury is considered a finder of fact.
Yep.
The judge determines what law applies to the case and will instruct the jury on that, but the jury finds the facts and then applies it to the law the judge gives them. That's what happens at the end. And really, juries are there to answer very specific questions at the end of the day. Now, it may take a lot of evidence to answer that ultimate question, but
And it may be a very simple answer, maybe guilty or not guilty, liable, not liable.
Right.
But
Yeah.
And then sometimes, even if you agree on the facts, like, okay, the defendant caused the wreck and they're admitting to it, what are the damages? Maybe that's the question of fact where there's a dispute. So,
and a lot of this is spelled out in that pretrial process leading up to the order of.
Right.
right.
So as a plaintiff, our job, we have a case that's going to trial. We sort of know what the witnesses are going to be. We know what the evidence is going to be. Our job is to synthesize that and present a case to a jury. We've got to present facts that we have to prove even just to stay in court. We have to tell a story, and we have to be compelling in some way to convince or persuade a jury that we're right. And the defense on the other side, they don't have a burden of proof, so they really don't have to do much of anything. But they're going to present their case as well, which often consists merely of calling into question our case, our facts,
poking
our
holes.
witnesses.
Yeah.
Right. So as a plaintiff, we really have to sort of have a detailed roadmap and a story to tell before we get to trial.
Yeah, Chris Clark, who's a lawyer in Macon, a really fine trial lawyer, was an adjunct professor of mine in law school, and I worked for him. And he used to say that, getting a plaintiff's case ready for trial is like going down a long hallway and making sure every door is shut. All the defense has to do is open one door and you lose. So you got to make sure they're all shut, and so it is that complicated process. What makes it more complicated and takes more time is, you hear somebody say that, it's like, okay, whatever, just get people to talk about it. And they give the documents and that's it. But there are so many legal issues that come into that. What's admissible? You have to be sure that your evidence that you put before the jury is admissible. You want to try to eliminate evidence that the defense may want to put in that is not admissible. And those questions aren't always clear. They're judgment calls, and sometimes really crucial issues will be a subject of evidentiary questions. So then we have what's called motions in limine, which are motions on evidence that's either to include or exclude some particular topic or document or evidentiary category that you can do, or you can sit and wait for it to come up at trial and then object to it being entered into evidence. And a lot of that comes down to strategy. So then you got to think about what's the strategy. So you're thinking about all the technical points that you have to do and making sure that your case is actually ready. Because like Andrew said, you can get kicked out of court. If you don't put enough evidence in to prove your claim, and it's called a prima facie case. You don't have, no.
You don't have to know what it means. You just got to hit the button.
That's right. That's Latin, y'all. So a prima facie case.
You actually already use one Latin phrase, a motion in limine.
Oh, that's true.
There you go.
No, that's
which
not
means
right.
a
Oh, no,
motion-
that's French.
It's French. Take that away.
Well, it's a romantic language. We already
Motion
saw
at the
it.
Yeah,
threshold.
that's a good point. All right. Well, anyway. So a prima facie case is you got to prove a certain elements to win the case. If you don't prove them, then the judge will rule that you haven't met them and the case doesn't even go to a jury. So like for negligence, the most common thing we have is the defendant has to have a duty to the plaintiff. There has to be a breach of that duty, and that breach of the duty has to cause, that's the third, damages. That's the fourth. So if you don't establish that there is a causation, for instance, and a lot of times what we deal with, that's medical causation. Sometimes you have to get a doctor to opine that, to a degree of medical certainty that the wreck caused the back injury, for instance. If you don't have that, if that evidence doesn't get in for whatever reason, your witness doesn't show up, or you didn't ask the right question, or the testimony doesn't say exactly what you thought it said, then your case can get just thrown out. And so you have to be very detail-oriented to make sure what is said really can get you past those legal hurdles, because
You have to do that at kind of 2 points. You have to be able to tell the judge and prove, convince the other side that you are going to have that evidence at trial, and then you actually have to have that evidence at trial,
Right.
Which is,
So let's talk about some nuts and bolts, Paul. Years ago, you and we came up with some checklists and sort of a method that we have used in this firm to prepare for trial.
right.
And frankly, it's an ever evolving checklist, but relying on that has really helped us be able to prepare for trials in an organized and efficient manner. Of course, it depends on the case, but rule of thumb, how far in advance of a trial date do we start pulling out our checklist and implementing the steps on it?
I'd say about 3 months. 3 months gives you enough time. And the point of the checklist is there are certain things you need to plan ahead for, especially when they include other people. You need to, if you have experts, if you have witnesses, you need to make sure they know when the trial date is and they don't have a vacation planned or whatever. But then a lot of times we'll have animation, we'll have videos, we'll have medical illustrations. We use third parties to create those. Well, that takes some time. And, we have had times where we forgot that in the checklist and we're 2 weeks before trial and then they charge us more to do it. So, you got to make sure you have those kind of nuts and bolts things of how are you going to tell the story to the jury that's going to be effective. And one thing that may not be obvious to our listeners who aren't lawyers is you don't really always think about that during the case, because you get so much minutia. You're trying to figure out what the evidence is, figure out what the story is, figure out what the testimony and the evidence looks like. it isn't until sometimes you have the whole thing that you really put it together on how are we going to tell the story. Now, we've been doing this long enough to where as the evidence comes in, the themes will start to present themselves. And we keep, one tool we use is Microsoft OneNote, and we'll keep notes as the case goes through about trial themes and things we want to make sure we put forward. So we're not at the end of the case trying to think, well, how do we want to try this case? And themes are important because at the end of the day, a trial to a jury should come across like storytelling. Not false storytelling, but there should be a narrative, there should be a story, there should be a theme that the jury can hear, relate to, and agree with your side of the story. There's two sides of the story. You've got to be compelling about that. It's almost like putting on, I would think, like a TV news a magazine, like a 60 Minutes or something like that. You have all the different parts of the filming, you have the interviews, you have everything. But once it goes on the air, it should flow very smoothly to where the end user doesn't see those evidentiary questions. They don't see that minutia that you had to push aside. They hear that what you want them to hear in a way that is going to make sense with the big theme. So you've got to be able to get all the nuts and bolts to where it goes smoothly and the storytelling happens at trial while making sure you're still checking all those legal boxes. So there's a lot of it's three-dimensional chess at times getting ready for these things.
It is a production. I mean, you are producing a story.
Well, and that's why starting 3 months out is important.
Yeah.
Because it gives you time to handle all these things via your checklist in at a pace that allows you to also have the creative side and the production side ultimately to the jury figured out. So you're not scrambling. No, there's always some sort of scramble because trials are complicated. And as lawyers, we're always thinking of, okay, what's going to go wrong? How do we prevent what's, Right. But so starting with the checklist, it's as simple as at the beginning, let's notify all our witnesses of the trial date. Let's make sure that they have travel arrangements. Let's make sure that there are hotel rooms. Let's make sure that for all of our medical records that we have the correct certification so that they can get into evidence. And for each item on the checklist, we found that it has to be assigned to a specific person, whether it's a lawyer or a paralegal, and that there has to be a due date in sufficient time that we can move to the next item on the checklist. So I think that's important. Have a checklist, and if anybody, lawyers out there, are interested in, we're happy to share our process with you. But each item on the checklist has to be assigned to a person. Yeah.
And we are trying to ever evolve with our technology we use and our case management and trial prep. I think we will put that checklist on. We now use a case management system called FileVine, which we like very much. But we'll add that checklist in the FileVine. But we've got it on just a Word document, I think. So, but FileVine allows you to assign it to somebody. Yeah, and then also it's important for the lawyer. The lead counsel should be making sure that everything's being shepherded towards trial, that everybody's doing the things they need to do on time.
Yep.
The checklist helps to where you don't have to recreate the wheel every time, and you can go about the work you have to do without. You can add things to the checklist, but you don't have to worry, did we get a hotel room, because that's on the checklist and it was
you
done
look at
2
it
months
and
before.
it's done.
Right.
Yeah, we'll ship office supplies. I mean, you're going to set up at a place and you ship boxes of staples and.
We've got these trials in California. One of the things we could do is get a short-term rental, and we're going to ship office supplies and a printer and stuff, so we can.
You got to do that before you get there,
right?
Yeah. So the checklist goes from early on, some sort of basic mundane housekeeping things, and then as you go forward, you get to things like preparing witness examinations. So Paul is going to do the direct examination of Dr. Smith. There's an item on the checklist for him to prepare that direct examination. And hopefully do it well enough in advance that he's not, 12:30 in the morning the night before Dr. Smith's testimony trying to create that examination.
Right. And sometime, and you're going to be editing it up until 12 o'clock the night before, but you hope your basic questions are already in line.
You talk also about the order of proof.
Yeah.
Different people, that's kind of a generally known name for it. But
so that goes back kind of to our prima facie case, but it's making sure that you get all the evidence in.
But it is a document.
It is a document. So you have, your your points that you have to make, and we'll have a checklist as we go through trial to make sure that everything that we need to get into evidence is into evidence.
That was one of my first jobs in my first trials, was that the checker of the order of proof.
It's very important because in trial you have so many things going on. If you're not tracking that stuff, you can just forget, because it's not like it's not an important part of your storytelling necessarily, but it's something that has to get in because you have to make sure your record, because remember, if you get a big verdict or if you lose a case, it's going to be appealed.
You're going upstairs.
You can't go to the Court of Appeal. The Court of Appeals doesn't get to watch the film of the trial. They have a record in front of them that you have to be able to cite to. So you got to make sure that's in place, and that's the tricky thing. We'll get to trying cases another time, but like it's the idea of being in the middle of trial, making strategic decisions about what to do, what to object to, what not to object to, what to argue, and deciding do we want to win this because could this be an issue on appeal? And or do we just want to let it go because it's not that important to the jury determination? It's one less thing for the other side to appeal on. So that's in the trying cases. But to your point,
I've got an example though of sort of a order of proof. It's sort of mundane. It doesn't come up that often, but it has a potential. Jurisdiction. Okay.
Sure.
Now, typically in trials these days, the parties will stipulate to venue and jurisdiction. But if the defense does not stipulate to that, you have to have someone who can testify that the corporation or the defendant is a resident of the jurisdiction or is subject to being sued in the jurisdiction where the court is.
Right.
So if it's a personal, if you're relying on personal jurisdiction over a person who's a defendant, they need to be a resident of the county where they've been sued in most situations. And if there's no stipulation to that, you have to have, typically what you will do is you will bring that defendant during your part of the case and ask them, where do you live? Or where did you live as of such and such date? And if you don't do that, technically, if you close your evidence without having done that, the defendants can stand up and say, Judge, we move for dismissal based on lack of jurisdiction. They hadn't proved it, and the court could dismiss the case.
Right.
Yeah, really important things like that to either make sure it happened before you got to trial or when you get there. We talked a lot about the record and getting these things admissible. It's probably worth just a little discussion about this. Trial happens sort of in a box where there's a whole body. You can go on the internet and you can find out a lot of information, but the trial is supposed to be the issues that are being decided are decided on the record that is presented at that trial. So you might be able to go pull up real quick that, on the Department of Corporations that this corporation's headquartered here, or the police report that's at the police officer's, on his desktop computer says that it happened here. But if you do not get that into that trial record, into the box of the trial, because of the way that our system is structured, if it's not there,
it doesn't count.
It doesn't count.
It didn't happen.
It did not happen. So, and that's an important part of the system and how it functions. It's important that the record, everybody knows what the evidence is, and it's decided on the evidence, not on stuff outside.
Yeah, you want the decision, the jury's decision, to be made on admissible evidence,
Right.
And that's what keeps it from being just the court of public opinion.
Exactly.
But back to the technical stuff. So how we prepare for trial, what we want at the end of the day is to have a trial notebook. That's how we have tried our cases. And a trial notebook is a 3-ring binder that's got everything that we need for that trial in there. Now, it may not have all the exhibits. We probably have an exhibit binder or exhibit, separate if we have a lot of exhibits at least. But that should have everything we need. We try to stay on the edge technologically of what we need, but that we have not found a way to bring organization within trial anything better than the 3-ring notebook with something in it. Now, we used to put that together a month ahead of time and then just keep updating it almost daily and go through a tree worth of paper to get there. We have since started using technology to do that because we'll have a folder that we're working out of, a trial folder, which is a online folder to have documents, and we'll break that up into things like voir dire, which is the jury picking, and opening statement, all the different phases of the case.
French.
Yeah, there you go. No sound. But what the tools we use, because I think this is sort of a how-to as well, is we rely, like we said, on OneNote, It's a place you can keep notes. You can store little bits of information. You can have links to your exhibits, because sometimes we've gotten a lot better about this. It used to be we'd name our exhibits or number the exhibits, before trial, and then depending on what happens with motions in limine and what we decide to put on or the final version of a exhibit, it can change, and so we may renumber them and that kind of thing.
Now we start with Exhibit 29.
Exactly. Well, now we start using them through discovery, and if we use them in a deposition, that's going to be the exhibit number at trial, and we found a way to do that. But still, you put your exhibits in there with these links, and so you're using the same exhibits, but it doesn't go into the trial notebook with the exhibit list until that's finalized. Once something's finalized, it gets printed out and put in the trial notebook, and that has our checklist. And for exhibits, for instance, we have to do two things. Is it authenticated? And is it admissible? So we have to prove that it's an authentic document before it can be admissible into evidence. A lot of times the defense or the other side will stipulate to authenticity, but if not, we need to ask, I'm asking Stephen, all right, do you recognize this photograph? Yes, I do. And does this truly and accurately represent the vehicle as it looked on, March 3rd, 2022? Yes, it does. And then it's authenticated. The photograph is authentic. It hadn't been doctored according to the testimony. And then you say, Your Honor, I move to admit, Plaintiff's Exhibit 5, whatever it is. So we need to know, but if it's already been stipulated to those things, we don't have to do that.
Right.
And so we need to know what we have to do. And with each exhibit, it's either stipulated to, it gets in on its own, or a witness has to authenticate it to get into it. And so we have to go through in our trial notebook and make sure that we know, how are we going to get each piece of evidence in?
It's got to be the right witness.
Right.
So you got the two pieces get it admitted, but the witness that it does it all, you also have to have them satisfy the criteria of having the foundation to authenticate that document. You can't just go pick some rando off the street and say, hey, does this look like a true and accurate copy of this picture? And they'd be like, sure. That's not going to, even though they say yes and that it's authentic, they don't have the foundation because they don't have the personal knowledge or the requisite knowledge to say, yes, that photograph is an accurate depiction of what it is representing, and there's no alteration that I am aware of.
So we have that issue right now that we're working through in a case we're getting ready to try in February, where we have a document for a company that was found online from their company website. So we know it's their document, but saying, hey, we pulled this off the internet doesn't authenticate it. So we have to get someone from that company to either fill out a certificate for us saying, yes, this is an authentic document of this particular company, or have somebody come to trial to say that.
That's right. It's just like Abraham Lincoln said, don't read everything and believe everything that is on the internet.
And
I think he tweeted that.
One of the tricky things with that too, you talk about getting ready, as people who listen know, we're trying cases all over the country. That we got a case in California. Well, California, what you have to do to authenticate a document and the rules of evidence are different than Georgia. And
it's
those
weird
are
that something in
federal
California
court.
is different from Georgia, but we're
So anyway, we have to make sure that we actually know what the rule says there, and following the right system to get it in. So that's the stuff that takes so long. The fun part is what you see with the whiteboard and think like how are we gonna tell the story? But the story can only be told if you prepare to where you have gotten your case ahead and you've anticipated as much as you can for the other side. Our philosophy is if you're, you can relax and be, be loose and try the case how you want to and flexible and in the moment, spontaneous, as long as you are so over prepared that you don't have to worry about the rest.
Yep.
And that's how we prepare for trials is we're trying
good
to
athletes playing a ball game. They practice that one maneuver, that one play over and over and over again. They're just out there having fun at that point.
Yeah. Well, and you also got to keep in mind Mike Tyson's wisdom.
Earlier in his days.
Everybody's got a plan until they get punched in the mouth.
Which reminds me, let's end this. I got a story that includes you and me trying a case. We were trying a case down in Waycross years ago, and we were very well prepared for this case, but it was a real slugfest. It went back and forth every day. Like we get down to the first day, oh, we're going to lose the case. Second day, oh, we're going to win the case. Third day, oh, we're going to lose the case. It was really a back and forth battle. And one of the things we had is we had an expert witness who was a neuropsychiatrist, and it was going to come down and testify. And the case had gone through different lawyers at times, and the disclosure of this expert had not happened in a very technical way that it should have happened. And so when we called this expert, the defense stood up and said they didn't do this, and we said, we looked at it and thought, oh man, we're in trouble. And so we had our file, we're going back for arguments, and we finally realized, listen, we're going to lose this. But he had made a report, which doesn't always happen in Georgia. The experts don't always do that. To get in a medical report, it has to have a certification. The certification has to have certain language in it. And of course, we had it for other medical records. So Andrew and I kind of got together during this argument and said, I'll keep arguing. And Andrew's like, I'll take this language and write it down on a piece of paper, go out with this report, have our expert who's waiting to testify sign it, and then when we lose this, we'll just admit his report, which was part of evidence.
Exactly what happened.
And so they got done. I just Andrew took about 10 minutes to get it all done. And I just kept on arguing about nothing, just said, well, we such and such, such and such. And the judge was pretty patient. And finally we got it. So he's excluded. So, all right, plaintiff, what's your next evidence? Your Honor, we'd like to submit this. And the defense started raising the hell. And then judge looked at it and said, looks fine to me.
Yeah.
So anyway, that's the point.
That's some gunslinging right there.
It was. Well, that was one thing that we have learned to be prepared on that.
We learned from that, exactly.
Yeah, we don't, because we were with a lawyer, they switched lawyers, and the lawyer beforehand we get along with real well, and it was more informal. Now you just, you don't ever know when they're going to file a lawyer, bring somebody else in. You might make sure your, I's are dotted, T's are crossed. But
I watch the skies for the parachute counsel.
But that's the type of stuff, if you are prepared otherwise, you can do in the moment.
Yeah, right.
All right, guys. How do walruses cry?
How?
They blubber.
And on that note, we apologize yet again. But that is it.
Good thing no one's listening.
Yeah. Sorry, Mom.
That was a good one.
That was.
That was. Well, thank you for listen to another episode of Just for Y'all. We'll see you next time. Bye-bye.
Peace out.
Thanks for listening to Justice for Y'all, hosted by the attorneys here at Bowen Painter Trial Lawyers in Savannah, Georgia. If today's episode resonated with you, or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that at Bowen Painter Trial Lawyers, we're committed to justice for y'all.